Hello, my name is Richard Kim, and this is my oral presentation for Family Law LA 330. I am currently a student in the paralegal program at American River College, and I hope to get my paralegal certificate this December. Today, I am presenting two articles that discuss premarital agreements. First article, Evaluating the Enforceability of a Premarital Agreement by attorney Christopher Melcher, published in the Family Law News, 2009. Second article, Mediating Prenuptial Agreements by attorney Frank Garfield, published in the Family Law News, 2010. Issues. Issue number 1. What practices will maximize the future enforceability of a premarital agreement? This issue is addressed in the first article by Christopher Melcher. Issue number 2. Is mediation a better way for a couple to discuss and prepare a prenuptial agreement compared to the traditional model? This issue is addressed in the second article by Frank Garfield. Rules. The first article by Christopher Melcher addresses the California Uniform Premarital Agreement Act, California Family Code, sections 1600 through 1617, which govern premarital agreements in the state of California. The second article by Frank Garfield addresses the California Evidence Code sections 1115 through 1129, which govern mediation. First article by attorney Christopher Melcher, Evaluating the Enforceability of a Premarital Agreement. In this article, Christopher Melcher's primary goal is to explain how to prepare and draft a premarital agreement which has the maximum probability of enforceability in the future if the need arises. Christopher Melcher emphasizes that enforceability depends upon compliance. Specifically, enforceability depends upon compliance to the California Premarital Agreement Act, Family Code section 1600 through 1617. Thus, Christopher Melcher focuses on the California Premarital Agreement Act to discuss and to advise on the topic of premarital agreements. The California Premarital Agreement Act provides that a premarital agreement will not be enforceable if 1. The agreement was involuntary, 2. The agreement is unconscionable, or 3. The agreement violates public policy. These are the three key factors for enforceability of premarital agreements in the state of California. Involuntary, unconscionability, public policy. These are the three key factors, which I present to you on this table, this 3x3 matrix, on the left-hand side. Involuntary, unconscionability, and public policy. These are the three key factors of enforceability of premarital agreements in the state of California. And this table, this matrix, provides a framework for a discussion of Christopher Melcher's article. The first factor is involuntary. In the state of California, a premarital agreement will not be enforceable if the agreement was involuntary. Independent counsel is an important element of this particular factor. Both parties must have independent counsel. Now, a party can waive their right to independent counsel, but there must be documentation that they were advised to get independent counsel, that they expressly waived representation, and this needs to be done in writing, and that the party waiving independent counsel is aware, fully informed, and understands the language of the explanation as well as the writing of the premarital agreement. The second element is a 7-day waiting period. This is 7 calendar days, and this is a 7-day waiting period between the presentation and the explanation of the premarital agreement and the ultimate signing. Melcher recommends that the premarital agreement negotiations and signing be done far in advance of the marriage so that there is no time pressure. And then the third element of the involuntary factor is good faith. And by good faith, I mean that there is no duress, fraud or undue influence. So no duress, fraud, or undue influence. So the three elements of the involuntary factor of enforceability are independent counsel, 7-day waiting period, and good faith. Moving on to the second key factor, unconscionability. In the state of California, a premarital agreement will be unenforceable or will not be enforceable if the agreement is unconscionable. So the three elements of unconscionability are inadequate disclosure. Okay, so there needs to be full disclosure of property and financial obligations. The second element is procedural unconscionability, and that refers to bargaining power or unequal bargaining power. For example, let's say one side has a lot of money, wealth, and the best lawyers, and the other side doesn't have money, or maybe they don't have representation. So that refers to procedural unconscionability, bargaining power. And then the third component, or the third element, is substantive unconscionability, and that refers to an agreement that is unreasonably one-sided and favors one side. So basically one side gets everything and the other side gets nothing. So inadequate disclosure, procedural unconscionability, bargaining power, substantive unconscionability, unreasonably favoring one side or one-sidedness. And those are the three elements of unconscionability. And now moving on to the third key factor of enforceability is public policy. In the state of California, a premarital agreement will not be enforceable if the agreement violates public policy. So the three elements of this public policy factor is penalty provisions, personal standards of conduct, and provisions or agreements that promote divorce. So in the state of California, there cannot be penalty provisions or penalties conditional upon personal standards of conduct. For example, provisions requiring marital fidelity, children's religion, domestic services, or companionship are void, and they can't be tied into penalties. And any kind of provision that promotes divorce is considered to be against public policy and would be considered to be void. So involuntary, unconscionability, public policy, these are the three key factors of enforceability in premarital agreements in the state of California. And this basically is the framework and the meat of Christopher Melcher's article. Now that was the first article. Moving on to the second article. The title of the second article is Mediating Prenuptial Agreements by Frank Garfield. Now Frank Garfield here basically explains and makes an argument for mediation in the prenuptial negotiation and preparation phase. He argues, or he makes a good argument that mediation may be, for many couples, a better way to proceed prenuptial negotiations. Mediation tends to be couple-centric, meaning that the couples are more actively engaged. It's actually the couples who are negotiating, and the mediator merely serves as a guide and as an informational resource. So compared to the traditional model, the couples have to be actively involved, and they are the centerpiece of mediation. Mediation is designed to be collaborative versus adversarial. So instead of arguing over positions, it's about looking for common interest and common ground and building on that, so common interest. In the state of California, under the California Evidence Code, mediations are confidential. So that provides a safe zone for the conversations. And the parties in the mediation, they're free to consult their own attorneys, accountants, other consultants to give them advice pertaining to the prenuptial negotiations. And in fact, the mediator serves more as a consultant. The mediator technically needs to be neutral and actually works for both sides and serves as a consultant and as a informational resource. Now, the traditional model does not have a mediator. It has the two parties and their two attorneys, and the traditional model tends to be attorney-oriented and adversarial. Now, the traditional model may be more appropriate, perhaps the matter's simple and the two parties don't really want to engage actively in negotiations. But there's various situations where the traditional model may be more appropriate. But mediation needs to be strongly considered because it may be a better way for many couples. And that's basically this is basically, in a nutshell, the second article, Mediating Prenuptial Agreements by Frank Garfield. Conclusions from these two articles. From the first article, I would summarize the conclusion of that article as compliance. Compliance is the key to composing an enforceable premarital agreement. Compliance is the conclusion of article number 1 by Melcher, evaluating the enforceability of a premarital agreement. So if you comply with the California Family Code, the Uniform Premarital Agreement Act, you're more likely to have an enforceable agreement. The second article, Mediating Prenuptial Agreements, I can summarize the conclusion of that article with collaboration. Mediation provides a collaborative option for prenuptial negotiations, which may produce a more satisfactory outcome or more satisfactory outcomes. So conclusions are compliance, collaboration, compliance, collaboration. Lessons, what I learned. Codes, enforceability, and mediation. Codes were the first thing that I learned from these articles. I was not aware that there were specific statutes addressing premarital agreements and mediation. So premarital agreements in the state of California are governed by Family Code Section 1600 through 1617, and mediation is governed by Evidence Code Sections 1115 through 1129. And the codes are important, especially for any time we deal with issues, we need to look at the actual wording of the actual code. So these are the codes that govern these two particular issues in the state of California. The second is enforceability. In the state of California, the California Premarital Agreement Act provides that a premarital agreement will not be enforceable if the agreement was involuntary, the agreement was unconscionable, or the agreement violates public policy. So these are the three key factors of enforceability that I'll carry forward with me, and I would recommend that people that other paralegals carry forward with them in this course and in the future. Involuntary unconscionability and public policy. And then mediation. Keep in mind mediation. It's a more collaborative way to handle prenuptial negotiations. Premarital agreements or mediation is considered to be good public policy by the state of California. And actually, it may be a better way to produce a more friendly, mutually beneficial arrangement or a premarital agreement. So codes, enforceability, and mediation are the three key lessons that I learned in this exercise in reviewing these two articles.